Are you on a permanent residency status here in Canada and you did something, maybe you got convicted? Well, there is a possibility, huge possibility, that you will gonna be bound for deportation back to your own home country. So if you are convicted with a serious criminal offense and are not a Canadian citizen, you may be ordered to leave the country with no chance of appeal. A person who is a permanent resident faces deportation if their offense or sentencing meets the definition of serious criminality under Canadian law. Any of the following are considered serious criminality: conviction of a criminal offense that carries a possible prison term of 10 or more years, even if the actual sentence is less than 10 years, sentencing of more than 6 months in jail for a criminal offense, or conviction of a crime outside of Canada that would carry a prison term of 10 or more years if committed in Canada. To continue, foreign nationals may be deported if they convicted of a serious offense as defined previously, but also face deportation if found guilty of two fairly minor and possibly unrelated criminal offense. A foreign national generally has no right to appeal their deportation order, while a permanent resident loses the right of appeal if they receive a sentence of 6 months or more. If deported, you are generally barred from returning to Canada regardless of how many years you resided in this country prior to your deportation. A deported person may apply for an authorization to return to Canada, or ARC, in order to return, but there is no guarantee that the ARC will be granted. Here are the following crimes are among the criminal offenses that may result in deportation: impaired driving due to alcohol or drugs, assault causing bodily harm, sexual assault or domestic violence, drug trafficking, theft over $5,000, possession of a restricted weapon with ammunition. For non-Canadian citizens, it is important to understand the immigration consequences if you are charged with a crime, given that a guilty plea or conviction may result in a loss of permanent residence status. And even if a judge is sympathetic to your situation, Canadian law requires that a permanent resident cannot appeal a removal order if they are convicted of a crime punishable by prison term of 6 months or more. Humanitarian and compassionate consideration may be accepted as grounds for the appeal of a deportation order under the IRPA 63.3. But only if your sentence is less than 6 months in prison. Deportation is clearly devastating consequence emotionally and financially, particularly when the affected person has lived in Canada for many years. A deported person faces long-term separation from any family members remaining in Canada, which may include their children, grandchildren, and parents. And these family members are also commonly suffer negative impacts, including psychological stress, financial hardship, and the loss of a caregiver. Further, many deported persons are returning to a country or place where they have no residence, poor work opportunities, and or dangerous conditions due to political conditions in their country of origin. If you have received a removal order and are facing deportation, you likely have compelling reason for remaining in Canada. If you have the right to appeal, you may make a removal order appeal to the IAD, or Immigration Appeal Division. The appeal must be made within 30 days of receiving the removal order, and it is your opportunity to convince the IAD why you should be allowed to stay in Canada.